of the same classification. A member of parliament is an example or type of the people he represents. He is one of them. He is the people. As opposed to the delegate, who is described as a person chosen or designated to represent the other. My lords, the mandates of representation are different from, of representatives are different from those of delegates. The representative represents the will of the people. He represents directly, while the delegate has power limited to the instructions given to him. Having said that, my lord, it is our submission that where they are required to carry out consultations, the members of parliament, in enacting this Constitutional Amendment Act, duly carried out consultations. It is evidence on record which my land friends will be pointing out to show that due consultations were carried out. Our firm stand, my lords, will be that the petitioners have not put up any case whatsoever by their submissions or evidence to justify this honorable court to interfere with the will of the people as expressed by the representatives in enacting Constitutional Amendment number 1 of 2018 or any of the provisions thereunder. My lords, in the alternative for our stand, we shall pray that in the most unlikely event that this honorable court finds that there is anything that vitiates the will of the people, or that there are any provisions of the Constitutional Amendment Act 2017 that are not sustainable or that are intolerable defective for any reason, this honorable court be pleased to sever those which are not sustainable and uphold those which are not effective. We shall be making that application. My lords, we have structured our response as follows. I have a big team who will be making submissions precisely and to the point. On issue number 6, B and E, we shall be represented by Mr. Richard Adrode and Mr. Solomon Chirunda. They'll be brief and precise. On issue number 5, issues number 5, 6, C and D, we shall be represented by Mr. Rafi Rawara Elisha and Mr. George Karemera. On issue number 7, A, B, C, E, we shall be represented by Mr. Henry Ruka. On issue number 7G, we shall be represented by Mr. Madete Geoffrey and Mr. Tamale. On issue number 9, issues number 9 and 6F, we shall be represented by Christine Kawa, while on the remedies, it will be the Solicitor General and myself, who will do also the wrapping up. I now call upon Mr. Adrode make our responses regarding issue number 6, B and E.
B and E. My lords, I'm still Richard Adrole, Senior State Attorney. My lords, I'm going to first deal with issue 6B. And my lords, this issue, we touched on some of these issues when we were making our submissions on issue 6A. So, my lords, what I'm going to do there is I'm just going to reiterate our submissions we actually made for A because they apply to B. However, my lord, I'm going to restrict myself on the application by Mr. Mabirizi to strike off paragraphs 5 and 8 of Mr. Keith Muhakanizi's affidavit. My lords, the affidavit of Keith Muhakanizi, my lords, if you look at the petition, the petition, constitutional petition number 49 of 2017, my lords, that is Mbale Mabirizi versus the Attorney General. My lords, in paragraph 5, Mr. Keith Muhakanizi discloses his source of information, and he says that I know that the office examined the bill and found, among others, the proposed amendments to the Constitution, and then he narrates. My lords, it is our submissions that this is not hearsay evidence as put by Mr. Mabirizi in his application. My lords, when you look at section 59 of the Evidence Act, my lord, it provides that oral evidence must in all cases, whatever, be direct, that is to say, A, it refers to a fact which could be seen. It must be the evidence of a witness who says he saw it. My lords, Mr. Keith Muhakanizi, when he was being cross-examined and re-examined, he reaffirmed that he is the accounting officer. He is the accounting officer of the entire nation in as far as financial matters are concerned. My lords, the information which he makes reliance on, my lords, he even goes further to attach the letter, the request from the clerk to Parliament. He also further goes on to attach the certificates of financial implications. And my lords, that information was the basis upon which he deponed the affidavit, my lords. So, my lords, it's our prayer, without further ado, that this court be pleased to dismiss or to reject or to find that the application by Mr. Mabirizi is without merit. I so pray. My lords, without wasting court's further time, I'd like to delve into issue 6E. My lords, the issue at hand is whether the alleged failure to consult on sections 2, 5, 6, 8, and 10 is inconsistent with and in contravention of Articles 1 and 8A of the Constitution. My lords, in the opening remarks of the Deputy Attorney General, he went at great length to explain the respondent's position on this issue. However, what I'm going to try to do is to navigate through it so that I do not touch on some of the issues he actually has already dealt with. My lords, the evidence on record is that when the bill was introduced in Parliament, the Right Honourable Speaker referred the bill to the Committee of Legal and Parliamentary Affairs for consideration and bill scrutiny. My lords, it's also on evidence that when the Speaker had finished referring the bill, he also urged members, this was emphasis, to consult members of the general public and engage them on the bill. My lords, this is on page 4,746 of the answer dated 27 September 2017. My lords, during the committee stage, my lords, while the committee was considering this bill, the committee interacted with a number of stakeholders, and some amendments as a result were brought up at the committee stage. Others were dropped. My lords, those that were dropped and some others which were not dropped found their way on the floor of Parliament, my lords. And my lords, that was the answers will bear us witness that in the answer dated 20th December, Robert Kafero puts the Speaker on notice. Michael Tumusime further prescribes the term of Parliament. And Honorable Nandala Mafari also comes in with issues to do with term limits. My lords, I'll now go and deal with the legal issues here. And my lords, probably I'd like to inform court that I will deal with the legal principles which the Attorney General, except for those that Attorney General has touched on, but I'm going to try to navigate carefully so that I do not find myself in his realm. And similarly, my lords, my colleague Solomon Chirunda will then tie up the issues of evidence, articulate the tests that Parliament would apply in determining whether or not consultations or participatory democracy was actually carried out, my lords. My lords, I refer this court to Article 1 of the Constitution, and my lords, 1.1. My lords, Article 1.1 is to the effect that all power belongs to the people and shall express their my lords, who shall express their sovereignty in accordance with the Constitution. That is Article 1.1. My lords, under Article 1.2, the people shall be governed through their will and consent. My lord, their will and consent is the key issue here. My lords, in issue 1.4, in Article 1.4, my lords, the people shall express their will and consent on who shall govern them, how they should be governed through regular, free and fair elections, my lord. My lords, when reading Article 1, we should not lose sight of Article 38. And my lords, 38 is to the effect that every Ugandan citizen has a right to participate in the affairs of government, individually or through their elected representative, but in accordance with the law. My lords, Article 8A of the Constitution deals with national interests. And my lord, it states that Uganda shall be governed based on principles of national interest and common good, enshrined in the national objectives and directive principles of state policy. My lords, of particular interest there is directive principle number 2. My lord, it opines that the state shall be based on democratic principles which empower and encourage active participation of all citizens at all levels of their governance. My lords, our democratic government contemplates, our democratic government contemplated in the Constitution provides for representative and participatory democracy, which make provisions for the public to participate in the lawmaking process. And hence, my lords, the provisions of Article 1, Article 8A, Article 38, Article 79, 90, 91, and 94, my lords. Further to that, my lords, the rules for procedure of Parliament, my lords, we have notable rules there that also allow representative and participatory democracy. My lords, these rules are Rule 23, my lord, which deals with sitting of the House to be open to the public. My lords, Rule 116, which provides for Gazette, my lords, to put the public on notice on what is actually transpiring in Parliament. My lords, Rule 120, which provides for private members' bills. My lords, if a constituency member feels that their representative should bring a bill, he can also approach the elected representative. My lords, Rule 128, which makes reference to the committee, and that is an example of what exactly happened here when the Speaker sent the bill for scrutiny to the Committee of Legal and Parliamentary Affairs. My lords, Rule 205, which provides for special powers of the committee. My lords, the committee can summon anyone it wants in consultation, to deal with the consultation on matters that are currently in Parliament or at that committee stage. My Lords, Rule 230 also admits the public and the press to the House and the committee. My Lords, the people of Uganda, as exemplified in the preamble. My Lords, I don't want to go through the preamble because Learned Counsel Ogalo extensively dealt with it, but I'm interested in the latter part, which says, exercising their sovereignty and inalienable right to determine the form of governance for our country, and having fully participated in the constitution-making process through their constituent delegates, constituent assembly delegates, they have themselves a constitution that has a provision that has Article 38. My Lords have already alluded to Article 38. It says Ugandan citizens have a right to participate in the affairs of government, individually or through their elected representatives, but in accordance with the law. My Lords, it is our submission that in this regard, in light of Article 38, my Lords, they made provisions where individuals participate in the affairs of government through a referendum. My Lords, those provisions, if you look at Article 260, it's very expansive on where the people can directly be involved in the affairs of government. My Lords, I'll also this very constitution, my Lords, which is the People's Constitution, my Lords, also makes provisions for the members of Parliament to act through, for Ugandan citizens to act through their elected representatives. And my Lords, this applies in two ways. The first one being that they can act through their elected members of Parliament, but with ratification from the district councils. And my Lords, we have classic examples of this under Article 5.2 of the Constitution, which on what constitutes Uganda. My Lords, Article 176 on local government systems, 178 on regional governments, 189 on the functions of district councils, and many others, just to mention but a few. My Lords, also this very constitution that was made through the Constituent Assembly delegates also provides for that the public or members of the public or citizens can also solely be represented through their elected members of Parliament. My Lords, it is evident that in Uganda the people, through their constituency assembly delegates, dictated how public participation will be achieved in the conduct of their government. My Lords, it is our submission that members of Parliament go to Parliament to represent the collective will of the people of Uganda. And unless the Constitution dictates otherwise, like it does in Article 260 and Article 1 Clause 4, my Lords, then when Parliament speaks, my Lord, it speaks for everyone, my Lords. My Lords, when Parliament speaks, my Lord, what I wanted to say is that when Parliament speaks, my Lord, it is the people of Uganda that have spoken. That's what I intended to say. My Lords, on the issue of the test in determining whether Parliament ensured public participation, my Lords, I'm going to leave it to my colleague here to quickly sum it up and also provide distinguish between some of the cases that have actually been highlighted. So pray.
My Lords, may it please you, my name is Solomon Chirunda, Principal Legal Counsel to the Parliament of Uganda. My task is to prove to you, my Lord, that the test that is required in proving that public participation was actually facilitated by Parliament of Uganda, was complied to and was passed by the Parliament of Uganda in consideration, and eventually enacting the Constitutional Amendment number 2, 2017. My Lords, on the record, you already have the authority of Doctors for Life International versus the Speaker of the National Assembly of South Africa. It was submitted to you in Bundle E, from pages, Bundle E of Mr. Maviri's authorities, from pages 46 to 125. The test I'll request this court to invoke is contained in paragraph 146 of that decision, my Lord. The court held and put this as the test, and it said, I beg to quote, in determining whether Parliament has complied with its duty to facilitate public participation in any particular case, the court will consider what Parliament has done in that case. The question will be whether what Parliament has done is reasonable in all circumstances. And the factors relevant in determining reasonableness would include rules, if any, adopted by Parliament to facilitate public participation. It will include the nature of legislation under consideration and whether the legislation needed to be enacted urgently. Ultimately, what Parliament must determine in each case is what methods of facilitating public participation would be appropriate. In determining this, whether it is reasonable, the court will pay respect to what Parliament has assessed as being appropriate, and in determining the appropriate level of scrutiny of Parliament's duty, facilitate public involvement. The most important, my Lord, court must balance, on one hand, the need to respect parliamentary institutional autonomy, and on the other, the right of the public to participate in the affairs of government. In my view, this balance is best struck by court considering whether what Parliament does in each case is reasonable. End of quote. My Lords, that's where I'm going to base my submission. When we look at the rules of procedure, my Lords, it is our submission that, number one, the bill as required was gazetted, as required by the Acts of Parliament Act, and therefore the whole country was put on notice of what was going on in Parliament of Uganda. Number two, the bill, when it was referred to the Committee on Legal and Parliamentary Affairs, in compliance with Article 19, Sub-Article 3, and Rule 205, the Committee of Parliament invited and received individuals and memoranda from 53, it is on the record, my Lord, the Hansard attached to the affidavit of Mrs. Jane Chibirige, the Clerk of Parliament, 53 individual groups of citizens, including, my Lord, His Excellency, the President of the Republic of Uganda. Number three, both the committee and the Parliament of Uganda conducted open, public, and accessible hearing in compliance with Rule 23 and Rule 230 of the Rules of Procedure. Number four, my Lord, the Right Honourable Speaker implored the members to consult and involve the people. I will not belabor that, it has already been put there. Number five, that Parliament facilitated the consultations in two ways, and is on the affidavit of Mrs. Jane Chibirige. One, in adjourning the House to facilitate the members of Parliament to go and conduct consultations and involve the people in the affair of their government. And number two, by facilitating them in a financial manner to carry out these consultations. On this point, my Lord, the last thing that was done was the voting. The members of Parliament, it is on the record, voted in reflection of the will of the people that they represent. This is on the Hansards of 19th and 20th December 2018, attached again to the affidavit of the Clerk of Parliament, And examples can be, as was given in the testimony of the Clerk of Parliament in the witness stand of Herbert Ariko, who even brought, Honorable Herbert Ariko, who even brought documentary evidence to prove that he had consulted. Honorable Nambozo was here and told court that she voted in respect of the will of her people. My Lord, having done that, I would seek your indulgence to address court on the origin of this public participation. Very briefly, in 1 minute, I would like to state.
You reply, Judge.
In 1 minute, my Lord, I'm most obliged, that it has its roots in Article 25 of the International Convention of Civil and Political Rights, to which Uganda is a party, and is brought home by Article 5 of the African Charter on Human and People's Rights. What is important in this is that state parties like Uganda are required to establish powers and means by which individual citizens exercise the right to participate in the conduct of public affairs in their national constitution and in other laws. It is for the legal and constitutional system of a country like Uganda to provide this modality. Our submission, as ably put by the learned Attorney General and my learned colleague, is that the system is there and the people of Uganda made their choice in that regard. Lastly, on this point, my Lord, I'll invite you to refer to paragraphs 123 and 124 of the Doctors for Life case. It is instructive on the fact that the Parliament or respective legislators must be given a significant measure of discretion in determining how best to fulfill the duty to facilitate public involvement. They, in fact, allow Parliament to enact their own rules in this. And it is little wonder, therefore, that under Article 94, my Lord, Parliament of Uganda enacted the rules that involve 23 to 30 and the entire list as given by my colleague. My Lord, the evidence can be found in the affidavit of General Boa Chibirige at paragraphs 28, 30, 31, and 49 in petition number 5 of 2018. Paragraphs 3 to 7 of Honorable Grace Valieko's affidavit in the same petition number 5 of 2018. Paragraphs 3 to 14 of Honorable Samson Lokeris's affidavit in constitutional petition number 5. The affidavit of Honorable Musasizi, paragraphs 5 to 10, and the affidavit of Honorable James Kapoza in petition number 5 of 2018, paragraph 3 to 8. My Lord, the learned Attorney General did address you in his opening remarks, and to the effect that the MPs are representatives of the people of Uganda and not delegates. I have only one thing to say about that, and I will not repeat what he has said. The Parliament is not a Congress of ambassadors from different hostile interests, which interests each must maintain as agents and advocates against other agents. But Parliament is a deliberative assembly of one nation with one interest and one whole. Yes, as citizens, we do elect a member of Parliament. But once we do, my Lord, they become members of Parliament of the Republic of Uganda. And if our interests as a constituent differ from that of the whole, then the member of Parliament is required to stay away from us and go with the interest of the general good of the country. My Lords, to illustrate this, when a member of Parliament is elected under Article 81.4 and Rule 3 of the Rules of Procedure, they are required to subscribe 2 oaths, my Lord, 2 oaths. One requires them to bear faithful and true allegiance to the Republic of Uganda, and the other to give faithful service to the Parliament of Uganda. So as long as whatever is before them in exercising their constitutional mandate is for the betterment of this country, they are required to steer off from the individual local interests, take care of the public good. The cases that have been cited, my lord, one is from Kenya and the other is from South Africa. I will reply in 2 sentences. My lord, in Kenya, public participation, consultation is mandatory and is couched in mandatory terms in Article 118 of the Constitution of the Republic of Kenya. And in South Africa, my lord, Sections 59 for the National Assembly, Section 72 for the National Council of Provinces, and Section 118 of the provincial legislatures, my lord, couch it in mandatory terms. They chose to couch it in mandatory terms in their jurisdiction. In Uganda, the people determined 3 modes, as was illustrated by my learned colleague. My learned friend, most obliged, my lord. In conclusion, my lord, I invite you to find that the Parliament of Uganda, in whatever they did, in compliance of rules 23, 230, 128, 133, and Article 90, sub-Article 3, did what, in the test posed by court, was enough and sufficient to facilitate public involvement and to facilitate the people in determining how they will be governed. I so submit, my lord.
I only have one question to you. It appears to me that you concede that Parliament, members of Parliament, don't just represent their constituents. In that regard, the directive by the police restricting them to their houses and their constituents breached the law and the constitution, and in effect made it impossible for the well-intended Parliament decision to be implemented.
My lords, I steered away from that because it is the next issue that court is going to be addressed on by Mr. Bafirawa and Mr. George Kalemia. They will be able to answer to court on that, my lord.
So you say Parliament can do what it wants because public participation is not mandatory. It's up to the fact the people are on the receiving end. They are like beggars. Parliament gives them what it wants to give them. If it doesn't.
My lord, my submission was anchored in Article 25 of the International Convention of Civil and Political Rights and Article 13 of the African Charter on Human and People's Rights, that state parties are allowed to determine how.
I think that one is a misconceived submission. We don't get our laws from African Union or United Nations. Our constitution comes from the people, and if you read the Odoki report, that's where the will of the people comes from, not charters of United Nations. They come here, we can make them as acts of Parliament. You can't submit that public participation is from United Nations, I don't know, African Charter. No, go to the Odoki Commission and see what the people of Uganda say. We want to participate in the governance of this country, including the making of laws.
My lords, in my opening remarks, I was very clear and I said consultation is required where it is demonstrably justifiable in a free,
like making a constitutional
and democratic society.
Like making a constitutional amendment.
That's what I said.
Yes. So how can you submit that Parliament will consult us when they want, when they don't want? It's okay.
Councillor Kirunda.
Even in your home, you consult your children.
Councillor Kirunda, you made an interesting submission that once you're elected a member of Parliament from your constituency, once you get Parliament, you deliberate for the nation. You look at the interests of Uganda. How would you relate that to this particular petition?
My lords, I made a submission based on the oath that is ascribed by the members of Parliament. But in relation to this particular petition, the consultations that are in the affidavit of Honorable Baliegu, Honorable Margaret Muhanga, and as was earlier submitted by the learned Attorney General, that gave birth to this constitutional amendment as presented by Honorable Raphael Magezi, came and it was deemed by the mover of the bill, that it is in the interest of this country that, for example, the age restrictions on the office of president be removed. In his estimation, it was what the people had sent him to do, and it was his duty to sell it to his colleagues, which he sold, and it was bought, hence the amendment. They deemed it good for Uganda. When you go through all the debates that are attached in the answers of 18th, 19th, and 20th of December, my Lord. That is on record already, my Lord.
So the law is that members of Parliament, one of them can just stand up and they amend the Constitution. Just like that. Just like that. Because they are members of Parliament and they have lawyers, so they can say we have amended the Constitution. But the Speaker said this is not something we can do alone. It's in the Hansard. It's on record. This is not something we can do alone. We need to consult with the people. But now that is your post. Now you are submitting that was not required.
My Lord,
and we should hear as judges of the court, even ourselves, the judgments we make them on behalf of the people. We cannot make judgments that do not take into consideration the aspirations of the people of Uganda. We cannot.
My Lord, actually, Learned Counsel, you see, in that respect, your submission differs from what was presented by the Learned Attorney General. It was clear on when. It set up about 2 or 3 circumstances under which consultation is required, one of which he just repeated now. So if the Speaker of Parliament, in his or her wisdom, in so many words, I could say, owing to the importance of the matter before Parliament, we must go back to them and consult, whatever your definition of consultation is. You understand? Can you say it was not necessary in the specific circumstance of this case? You say, although the Speaker said it was not necessary. And then you tie it up, well, fortunately you say there are other people who are going to submit of this. You tie it up with, if the Speaker says, go back to the people, consult, and somebody intervenes and say, you can only do it my way, you can only do it this way. You cannot call A to join you and present to your people the case as best as you can. You must move within the sitting room only. Don't go to the dining, don't go something like this. Does it give effect to the wise decision by the Speaker of Parliament? That one concerns the people. But I agree that some other persons who are going to submit may have to answer that.
I'm most obliged, my Lord. The next issue will answer that, and I can't say it any better than my Lord Justice Kakuru said as regards the involvement of the people. I'll just spoil it, my Lord, and I leave it at that.
And you better not, actually, yeah. Yes, Attorney General. Well, my Lord, now I call upon Mr. Karemera George and Mr. Wafira Waratwat to respond to issues number 5, 6, C, and D.
My name is George Kalemera. I'm a principal state attorney. And with your permission, my lords, I am ready to address the court on issues number 5 and 6C. However, my lords, before I proceed, I most kindly seek your indulgence. We have one set of authorities who would like to adduce before the court. Your kind permission.
I hope they are not in the box fight.
And Learned Attorney General, Learned Attorney General, I was waiting for the conclusion of your submissions, and I would say, but I think this is an opportune moment, owing to the mention of authorities. The respondent will have to bind all the authorities, even the ones which was lodged in court, and lodge them afresh. We do not want a situation where it's already happened. This document is already come out. I don't want a situation where we are looking at your documents and one crucial document is missing and our decision goes this way instead of going this way because we missed out on some crucial document. So you will have to have them bound in accordance with the rules and resubmit them. My Lord, we shall oblige. And that will have to be done as soon as immediately.
My lord, do I have your kind permission to submit them?
Is it bound?
My lord, unfortunately, it is not in the...
No, for purposes of reference, yes, but you know the rules.
Yes, we will withdraw them, bind them appropriately.
Absolutely.
But they are separated and marked.
Bind them and serve everybody. Counsel on the other side, court, and...
They are not even highlighted.
They are, my lord.
I've seen them. There's no highlight.
Where?
Are those already presented with us? The one you see? Fine. Present them for purposes following your submissions. Hand them over to the clerical team and
Not say when you have done people, there are sufficient copies, people can also...
Yes. It cannot be done halfway. How do you follow? If you don't have the copies for counsel, you are not going to proceed on these authorities.
No, my lord, they are more than sufficient. We have a senior land colleague, Mr. Mbale, and his colleague.
Okay. Serve the lawyers on the other side. Where is my copy? Which one is my copy? Why are you denying me my copy?
Thank you very much, my lord.
Proceed.
Thank you so much. My lords, the two issues are issue 5, whether the alleged violence and scuffle inside and outside Parliament during the enactment of the Act was inconsistent and in contravention of Articles 1, 2, 3, 2, and 8A of the Constitution. And my lords, issue 6C is whether the actions of the Uganda People's Defense Forces, Uganda Police, in entering Parliament and allegedly detaining the state members is inconsistent with and in contravention of Article 24, 97, 2082, and 2113 of the Constitution of Uganda. My lords, we feel we can handle both issues together. My lords, it is the respondent's case that in order for the court to appropriately address these two issues, court would need to take into account the events, not just of the 27th September 2017, but the events as well leading up the 27th of December, being the 21st of September and the 26th of September. And my lords, these events have been adduced in evidence and attached to the affidavit of Jane Chibirige in constitutional petition number 5 of 2018, Honorable Gerard Karuhanga and 5 others against the Attorney General. And my Lord, of particular interest is pages 4739 to 4740, which is Annexure B, this affidavit, where the Right Honourable Speaker most usefully recounts the events from the 19th and 20th, the 27th, prior to her issuing the suspension order. My Lords, I will not bore the court with the details of those events, as we've been here and we can see the court has appreciated the events that led up to that day. My Lord, we feel that the court would benefit from the affidavit as well of Mr. Ahmed Kaboye, who's the clerk of Parliament, in his affidavit, in Honorable Gerard Karuhanga and 5 others against the Attorney General, and specifically paragraphs 8, 12, 13, 14, 15, 16, 17, and 18. My Lord, this is just to illustrate to the court the recount of the events that led up to the eviction of the members of Parliament on the 27th of September 2017. My Lords, the respondent does admit that during the eviction of the MPs from the House, there was a scuffle, but it's a submission that that scuffle was as a result of a lawful order by the Right Honourable Speaker after the MPs had refused to leave the House in accordance with an order she had issued. The Parliamentary Rules of Procedure, my Lords, which are in Volume 1, Tab C of the Respondent's List of Authorities. My Lords, it's our submission that the nature of our political system is that it is a multi-party dispensation. My Lord, so follows, and the implication of such a democracy is that members from different political divides and dispensations will need to be given a chance to openly debate and air their views, that make their contributions in the debate of parliamentary process prior to a final decision being made on the particular issue. And we beg to submit, my Lord, that these rights are the very notion of democracy under our 1995 Constitution. We contend, Your Lordships, that it is in pursuance of that fact that the Right Honourable Speaker, under the Rules of Procedure, does have powers, specifically under Part 8 in our Volume 1 of Tab C, to be able to maintain internal order and discipline during debate by means which she considers appropriate. And my Lords, these means include the power to exclude from Parliament for temporary periods members who disrupt proceeding or unreasonably impair a democratic process. My Lords, it's the respondent's case that much as the MPs do enjoy rights as they have submitted under Articles 1, 2, 3, 2, 8A and 97, which would enjoin them to as well debate and enjoy the privileges under those articles, the enjoyment of these rights, my Lords, is only valid when it is done in a manner that is acceptable and demonstrably justifiable in a free and democratic society, my Lords, like we have. My Lords, we get this submission from Articles 43.1 and 2, the 1995 Constitution, that mandates enjoyment of rights and freedoms not to be at the prejudice of others or against the public interest. My Lord, it's our submission that the public interest was very much curtailed when a group of members of Parliament ensured that the debate process of the bill could not proceed by visiting chaos, uncontrollable chaos in the House. My Lord, with your permission, my Lord, we beg to submit one authority that does give the test of the phrase of what is considered to be acceptable and demonstrably justifiable under Article 43(2)(c) of the 1995 Constitution. My Lord, this is the case of Charles Onyango Mbale and Andrew Mujuni Mwenda against the Attorney General in Constitutional Petition number 15 of 1997 at page 33, particularly paragraph 2. And my Lord, this authority is found in the copy that the court has most graciously just accepted. Authority number 1 under tab 1. And at this paragraph, the court speaks to a proportionality test.
What?
I beg your pardon, my Lord.
There are two authorities.
My Lord, authority number 1 in volume 5.
Authority number 1 is the constitutional petition.
Yes, my Lord, that is what I'm referring to. Charles Onyango Mbale
Yes.
and Andrew Mwenda.
Are you reading from the judgment of Petitions taken?
Yes, my Lord.
That was the dissenting judgment. The majority judgment was held otherwise. It was the fourth one.
Yes, my Lord.
But on appeal, the judgment of Petitions was upheld. So it should go to the constitutional appeal, not the court of appeal. Supreme Court decision.
I am most obliged for that is, my Lord. However,
because this cannot be law.
my Lord, the test remains.